Hi, I'm Stan Winford from the Centre for Innovative Justice, and I have here with me Rob Hulls, who's the Director of the Centre and a former Attorney General for Victoria, who introduced in 2006 Victoria's Charter of Human Rights and Responsibilities, on which Queensland's proposed charter is based. Hi Rob, can you tell us what should governments be aware of and what should they be thinking about doing in the lead up to new charters like Queensland will have?
Well, I think a fair amount of time is required to bed the charter down and an appropriate level of resourcing. Education and training about human rights and the charter across all sectors is critical. This needs to be across government, local authorities and the community sector. I think we allocated something like $6.7 million for that education and training over a 4-year period. And I think we also allocated almost $1 million to the community sector by way of grants to help educate in relation to the Charter. It was also very important that the Department of Premier and Cabinet run training. They ran training for all government departments and public authorities on acting in compliance with human rights. And so I think it was important that we had a substantial lead-in time to enable public authorities to become charter compliant, to review their respective policies and procedures to ensure that human rights were taken into account in any decision making.
What about within government? Was there anything that needed to be put in place to assist the government itself and departments to develop policies and so on in compliance with the Charter?
Sure, we established a human rights unit within the Department of Justice to provide advice to government on Charter issues. They actually provided statements of compatibility on legislative proposals and policy advice to other departments. It wasn't a huge unit, it didn't cost the earth, but it certainly greatly improved policy development early in the process, and that's exactly what you want.
Now, there would have been a lot of legislation on the statute books that was enacted before we had a charter in Victoria. What needed to be done about that?
It was very important that we had a stocktake of all legislation on the statute books to ensure that legislation was charter compliant and to look at whether legislation needed to be amended to adhere to the charter, or indeed it was such old legislation that it could be repealed. And that stocktake did lead to a number of surprising things. For instance, we found a piece of legislation on the statute books that said that women who were giving birth in prison had to be shackled, for instance, when they were giving birth. Well, of course, as a result of that stocktake, that legislation came to the fore and we were able to repeal that legislation. So a stocktake of legislation is important.
Now, you didn't introduce a standalone cause of action into the Victorian Charter, and I understand that's the position that they're taking in Queensland. Why didn't you?
Well, we did have a review mechanism in our legislation. I know there's one in the Queensland legislation, so that might happen down the track. But the Victorian Charter was never intended to have as its primary focus litigating human rights. It was more about dialogue between different arms of government and influencing policy development, so people's rights are respected in the first place, and that often means less litigation. If there's a breach of human rights, it can be litigated, and we've had some important examples in Victoria. But the primary focus of the legislation of the Charter was to change the culture across government agencies, and within the Victorian community. More respect for human rights, respect for people's dignity, and addressing issues before they arise. That can often lead to less litigation.
Did any other statutory agencies need new powers or functions with the advent of the Charter?
From memory, we also provided additional funding and functions to our Equal Opportunity Commission. We renamed it the Victorian Human Rights and Equal Opportunity Commission. That was tasked with giving annual reports to the Parliament on Charter compliance. That was a very important thing. It was sort of an implementation monitoring type function. And the Human Rights Commission could also intervene in Charter cases when important issues of interpretation were being considered by the court. So we thought that they were very important functions.
Okay, well, in conclusion then, what would you say are the sort of key things that governments need to do, just in summary?
I guess probably four things. Allow sufficient time and resources to properly implement the Charter. Don't skimp on the resources at the outset. It's important that you get that human rights culture embedded right across government and the education take place right across government at the outset. A communications campaign, very important. Try to bring human rights back to the everyday. So we had the human rights Charter champions out there talking about the importance of protecting human rights pursuant to the Charter. A stocktake of the legislation. It's important that all legislation on the statute books be Charter compliant, and establish that human rights unit within the Department of Justice, because that certainly plays a very important role right across government.
Great, thanks very much.